Good morning and welcome. We have got a really good guest today, Walter Bhengu. Thank you, Walter, for joining us. And Walter has actually, he reminded me of the first time that he was on the session, which was on due diligence a couple of years ago, Walter. And I still refer to your YouTube video recording for some of the points that you made in that, which was really good. But this particular case that we're going to get into now is an interesting one that has challenged some of those findings. And Walter, you were with the AG at one point in time.
Yes.
You joined one of the big consulting companies, also audit companies, not consulting companies, audit companies at one point, and have for over a year now, if I'm not mistaken,
Yeah.
been with SCA.
Yeah.
And just really pleased that you agreed and that you're joining us. And without any further ado, over to you, Walter. Thank you very much again.
No, thanks very much, Sean, and thanks for inviting me. And thanks to everybody on the session. It's always great to come here. I think it's my third time coming on this platform. I seem to come once a year, so I think that's a good frequency in that regard. But obviously, usually, I come when there's a case that has come out, which we need to balance the legal aspects and the supply chain aspects. So obviously, my interest in procurement has been because obviously at some point I had to head up a procurement function, and I got to deal with the nuances of procurement, but also see what the frustrations are. Because I think sometimes as lawyers, we come in with a rules-based approach, whereas I think you must have a risk-based approach. And this looks at the challenges that you face on a day-to-day basis. And the reason why, for instance, you've always got cases almost on a weekly basis on procurement is because there's always aspects that need to be dealt with at that point in time. But I'm happy that as the cases have come up, there's a bit of legal certainty that was not there in the beginning with regards to procurement, because obviously at that time the courts were dealing with some of these matters for the first time. Obviously, Sean will know when I don't agree with the particular case, I'm very vocal about it on certain platforms because sometimes I feel like some of the courts don't understand the practicalities and the challenges that a procurement professional needs to deal with. But secondly, for those who are legal advisors to procurement teams, it then also gives them a headache, because instead of having legal certainty and giving your client some certainty to say, no, this case can be won on this basis, it's always one of those things to say, we'll present the best possible case and try and convince the court and hope that the court will come to a particular conclusion. So today's session basically is speaking about two very important aspects, and the second one is very close to my heart, and I think that's why I've tried to speak about it a lot on different platforms. So the first one is obviously the usual disqualification of bidders. This one will always be there. You will always have bidders that are disqualified. Sometimes you'll even see big companies that you expected to have top class bids coming in being disqualified because of one of the two things that they might not have submitted in terms of the mandatory requirements. Or, for instance, from an administrative perspective, they didn't submit certain documents, and when you then went back to ask for those documents, they didn't respond, and you just had to move on in that regard. So disqualification of bidders will always be an issue. And I always tell the story about when I was working in procurement, we used to have a tender box that was literally at the reception area, right? And we had a closing time of 4 o'clock. So we gave this particular bidders about 3 weeks to respond. And it was not a complex bid which required, complex bids to be compiled. It was a simple procurement. And we gave them until 4 o'clock on a Friday to actually make sure that they've got their bids in the tender box, right? And at about 3:55, which is 5 minutes before we could close the particular bid, we then saw commotion outside at the parking area, because now in this instance there were 2 parking bays. So there was a parking bay at the front which had about 5 parking bays, because you don't want to cause congestion on a main road, but the main parking for visitors was at the back. And obviously, if you were to drive to the back, you would not make it within the 5 minutes. So we had a lot of bidders now, for instance, crowding that main road and blocking And to the extent that there was one bidder who was not able to submit their bid by the 4 o'clock cutoff, and they submitted at the 5 minutes past 4. So how do you ensure strict compliance to make sure that there's fairness in the process? Do you accept and say, don't do it next time? Or do you say, I'm sticking to what the rules are? In that instance, I can tell you free of charge, we stuck to strict compliance because we understand that if we accept that, there can be a legal challenge to say, but you said all bidders must be there at 4 o'clock. I was on the highway. I turned back because I realized I was late. Therefore, you've now prejudiced me. These are some of the arguments that a lot of you can relate with. So disqualification of bidders is one that is quite common in this particular space. And one of the things, for those who know, when I present, I like to give you some imagery that you can sort of relate to, which may not directly be linked to the particular topic, but hoping that it will stick with you for the rest of your life and you link it back to procurement. So on this particular picture, you'll see that this is the Comrades Marathon. From what I've picked up in the last 2 years, a lot of you on this platform have become runners. I'm not fit enough to be a runner. I don't know what the obsession is with the running because I don't have the greatest joints out there. But this particular picture is obviously of the Comrades Marathon. And for those who've run the Comrades or have watched the Comrades or know something about the Comrades, is that there's a 12-hour cutoff point for medals. So if you arrive, for instance, 1 minute past the 12-hour mark, you will not get a medal. And I want you to think about this particular type of strict compliance in how that tender box example relates, because I don't want any of you on this platform to have particular leniency with regards to that cutoff, and then you end up having challenges from those who claim that they would have submitted a bid in a particular point, but did not because they thought there would be strict compliance. I think be very clear, and a lot of tender documents that I've seen are very clear. It's in bold, it's in caps, that if you do not submit by the cutoff date, you will not be considered. So this particular aspect of disqualification of bidders, and I want to just quickly spend some time here before I go into the meaty part on due diligence, is I want you to remember these 4 things, right? Because you've got the Uber Gaplin case, you've got the Telkom case, you've got the now famous Tagobiza case as well. And now, obviously, we've got the Aventino case, which has now also tried to come up with the aspect of disqualification of bidders. And I want you to make sure that you understand these 4 concepts quite extensively, because I did touch on them a bit in my last presentation last year on validity period, but it's very important for us to spend a bit of time here so that at least you don't find yourself unnecessarily in trouble in that regard. And obviously, as procurement practitioners, you're always under pressure. You're under pressure from the procuring business unit, as an example. You're under pressure from the leadership of the organization. You're under pressure from some suppliers. You're under pressure from the scourge of a legal review, and no one wants to go through court and have their matter going all the way to the Constitutional Court and you're mentioned by name. And I've seen a couple of people being mentioned by name. You don't want that. You just want to come to work, leave your passion as a procurement practitioner, and make sure that you deliver for the business and support the money of the business, right? So the first thing that we always talk about here when we talk about a bid validity period, and this is what the Aventino case was also trying to explain here, right, is that obviously with the tender validity period, you must look at the entire tender process as a contract, right? And what contract, for instance, do most of us have? One, for those who are employed, you've got an employment contract, for an example. For others, if I see there's some advocates in the room, perhaps you've got a contract with for the premises that you're currently using for your practice, as an example. There are parameters that are set off the bat in terms of that contract, right? And the one who drafts the contract obviously will get burnt if there's any issues or errors at the end of the day. There's a legal concept that I don't want to use Latin in this particular session, but for the advocates in this and lawyers here, they will understand what I'm talking about. So always look at a tender validity period or a tender process as a contract, and make sure you put in place in that particular contract, right, aspects that are practical for you to implement, practical for the bidders to abide by. All right. So one of the biggest things that we picked up many years ago with a lot of tender documents over the years was that sometimes you want to finish an entire evaluation within 180 days. And Sean gave an example, I think 2 weeks ago, about a particular entity that got 1,800 bids, right? And if you've got 1,800 bids and you've got individuals who must sit and evaluate those 1,800 bids, because you must give everyone a fair chance here, by the way. So obviously there's pre-qualification assessments and then the actual evaluation kicks in. But you need warm bodies to sit there and sift through that particular information at that particular point in time. And remember, it's not only the procurement team that's sitting here, it's also the procuring business and any other independent parties that have been called into this particular session as an example. So making diaries sync as an example can be very difficult. So you find yourself in those 180 days not being able to actually sit down for your first meeting sometimes. And obviously, it's not something that you want to do because it looks a bit tardy, but these things happen and you need to be able, with a risk-based approach, to anticipate that these things happen, right? So what we picked up a couple of years ago with regards to the extension of bid validity periods is that a lot of the time, in terms of the SCM policy, in terms of the tender documents themselves, a lot of contracting authorities, organs of state erroneously added that if I want to extend the bid validity period, all bidders who submitted bids must agree to the extension. So this is what happened in the beginning. And I know a lot of you have course corrected, and especially after last year's session that we had, a lot of you have course corrected because at that point in time, it looked like something that is insignificant. But it became significant because if you say everybody, so you've got 1,800 bids, they're locked in. All of them, if you want to extend the bid validity period, must email you back. That means you must get 1,800 responses saying yes. Then 1,799 respond and one doesn't. Automatically, what you have done is you've led to the expiration of that particular tender. And that is what, for instance, the REF case that we had spoken about last year as an example, with quoting the UPEC uplink case, had actually spoken about to say you need to make sure that you stick to the parameters that you've set for yourself, right? So in that instance, previously, and I think it was similar with Takubiza, is that you had put in place, for instance, that particular requirement and not everybody responded. So remember, sometimes with bidders, they will submit a particular bid. 6 months later, there's been a change of personnel. The person that had been emailed, now the emails bounce, for instance. Or secondly, the emails don't bounce, but people just don't want to respond because they've moved on to other projects and they've got no vested interest in the particular bid that they submitted 6 months ago. Some of them will say, no, it's no longer worthwhile from a financial perspective to continue with this, but they don't have, for instance, the courtesy to respond. But because you put yourself in this particular hole, it's done. So that is what that REF case, for instance, that I spoke about last year was about, and what the UPEC uplink case was about, right? And obviously the Takubiza case in that regard. So what one needs to then do, and this is what Aventino did, because they anticipated such problems, because obviously they understood with the type of services they required that it might not be possible to get every single person. So what they did is they said, if we then write to you to extend, right? Only those bidders, for instance, who have responded in this particular regard will ensure that this particular validity period is extended, but also they will be the only ones in contention, right? I want to be clear here, so I'll slow it down a bit. So it means if there were 10 bidders, as an example, that had submitted bids in the beginning, and now you see that, hey, I need to extend my validity period. And of those 10, 5 respond, and all those 5 obviously say, no, sure, it's fine. Please go ahead. We understand that there are certain problems that you've encountered, and they extend, right? The 5 that didn't respond fall away because they've shown that they're no longer interested. Because remember, ultimately, here, it's about sustained interest in actually wanting to work with an organ of state in that regard. Then only those 5 will then be considered, right? So obviously, in this case, the bidder who had, for instance, not responded was not happy and said, no. You need to get everybody to agree that has bidded. And therefore, this disqualification was unfair. And the court here was quite clear to say, no. the wording that is in the particular tender document was very clear that you don't need to have a consensus amongst all the bidders that have submitted. But secondly, the second layer, which is the critical one, which is the grounds for disqualification here, is that the documents were clear that those who then respond and say, yes, continue with this extension are fine. Obviously, the one that says no is saying, hey, I believe I must be bound by what I submitted. If not, then I'm also opting out of this particular contract, right? So the court was quite clear in that one, and obviously the organ of state was found to be in the right, and obviously moved ahead in approving that disqualification. But the second layer here, which is the foundation of a tender validity period, is what we call timeous extension. It must be timeous extension. You cannot have a Lazarus effect for those who know the Bible quite well, right? I like to use analogies from time to time, so please bear with me. And I use different analogies and not just biblical ones as well. But the Lazarus effect is a concept that obviously is now filtered into normal lexicon within the world, right? The Lazarus effect is raising something from the dead or reviving something that is expired. So remember that the Lazarus effect, right? It's biblical, but it's now filtered into something that you can use in your lexicon, right? We had an instance with the ref case last year, or 2 years ago now, right? Where the validity period had expired. And then a day later said, oh, we're not gonna be able to award. Can we extend? But now what you've done is you've come after the contract has expired. And in this instance, this contract can't be revived as if nothing happened. You would have to start from scratch. So it's like what you do with an amendment document to a contract, right? They always say in those contracts to say that if you want a contract extension, you must do it prior the expiration of that particular contract, right? So for instance, if you're employed in a fixed term contract, as an example, and it's your last day at work, no one says anything, and you walk out the door and it's the next day, if they want you to come back on that particular next day, they need to give you a new contract. They can't say, no, we're giving you an addendum to the extension. So that's the principle that has been dealt with here with regards to the bid validity period. And I thought it was very important to speak about this because obviously there has been comparison to the Takubiza case to say perhaps this particular Aventino case is changed. Did I hear someone?
No,
okay.
no.
All right. Perfect. So in the Takubiza case, obviously they had to deal with that aspect of making sure that one, you timeously extend a bid validity period, but also you are clear with regards to whether or not you need a consensus for your bidders or not. And point number 2 then becomes, how can you make sure that this becomes something by design? So a lot of the times we put in place processes by default to say, the law says this, but we don't apply it and interpret it to how it suits our particular organ of state. So you need to ensure that you've got a procurement process by design. And you're going to see it later when I talk about due diligence, why having something by design as opposed to by default is an easier way to get through a procurement process and never have to always scratch your head on what you need to do. So the courts have been very clear over the years about the powers of a contracting authority, right? So you remember with regards to procurement, first and foremost, you look at section 217 of the Constitution, and then you look at the 5 elements, right? And then that translates to PFMA, for an example, in terms of those very same principles, right? It also filters, obviously, the Preferential Procurement Act, but that's something that we're not dealing with today. I want to deal with it at a seminal level, right? So you then look at Constitution, from Constitution to PFMA. From PFMA, you then must craft a policy that does not deviate from the 5 principles in the Constitution or the 5 principles in the PFMA. And you'll see there, I talk about section 38 at the bottom there, right? This SCM policy, because remember, a constitution and the law won't give you the details. Even the regulations themselves won't give you sufficient details that are contextualized to your organ of state. So the law says you must have an appropriate SCM procedures or SCM framework or SCM platform, right, for which is relevant for your particular organ of state. It's quite clear. So you need to make sure that there is actual clarity in your particular policy. So with regards to aspects such as these on bid validity as an example, ensure that there is clarity in your policy so that if ever there's a Rule 53 application made by a disgruntled bidder to say, can I see how you came to a decision to disqualify me? Can I see how you came to a decision to award a particular tender? You've got all your ducks in a row in terms of your SCM policy in that regard. And it links to, I think, a topic we spoke about 3 years back now, Sean, on the condonation powers of a contracting authority. Right? There was a case many moons ago, I think about 10, 15 years ago now, that spoke about the fact that the only way you can condone non-compliance by a bidder is if you've given yourself those powers, right, in your own policy and giving yourself those powers in your tender document. You can't claim powers that you never gave yourself. This is very important, right? But I want to be very clear here because I wanted to make sure I raise this to say you cannot give yourself condonation powers to extend a validity period, right? Condonation powers, right, are for your run-of-the-mill administrative requirements that you would have set for yourself. For instance, did you submit a tax clearance certificate or not? Was it an original tax clearance certificate? But I thought it's quite important here to say that don't plan for failure, but always try to anticipate whatever problems you might have. But you need to give yourself those powers and make sure that those powers align to the 5 principles of fairness, cost effectiveness, equity, and all the other principles that you find in public procurement. The reason I'm raising this, right, and why I'm raising this now is that there was a case yesterday that came out, I think, from the Constitutional Court, if I remember correctly, and it reminded me of the rationality test, right? So whenever, there's a review against some of the decisions that you make as a contracting authority, you might find that at some point a bidder might say that you are not rational in the way that you set up these rules in your SCM policy, right? So you must be able to show, for instance, what the legitimate purpose of that particular rule that you've set in your bid is in that regard. So when you talk about a tender validity period and then saying, I don't want consensus, right? Let's link it back now. I don't want a consensus from every single bidder. What is the legitimate purpose there? The legitimate purpose is to ensure that you economically, efficiently, and effectively deliver in procuring a service that will link to service delivery. So you see how I've linked it. So a lot of people don't see that procurement, right, is there to support a legitimate government purpose. And that's why in some cases you can have a rationality test. So you need to show whatever you've set as the rules and the parameters of, for instance, these particular aspects that you'd have raised in your tender documents or your SCM policy, link back to a legitimate purpose, right? And in some instances, there was a case, I'm beginning to forget all these cases now, but it's one of my favorite cases, which the name skips my mind now, speaks about that a procurement process must be assessed from a businessman-like perspective or from a business-like perspective, right? Do not force organs of state to make decisions that don't make commercial sense. Do not force businesses or suppliers or bidders in that regard to find themselves now contracting in something that does not make commercial sense. So in that regard, please make sure when you talk about this aspect of tender validity period and how you set the parameters for it, you make sure it makes sense, but still retains the aspect of fairness, equity, competitiveness, and the like in that regard. So this is one aspect that I thought was quite important to start off with before I go into the bigger part of the particular session, which is on due diligence. But the case had 2 aspects to it, and the court agreed, and I'm happy to say agreed with me in that regard, with regards to how we should look at disqualification of bidders and ensuring that organs of state are not hamstrung by such reviews. But luckily, obviously, once the Public Procurement Act is fully in effect and the regulations are fully in effect, we'll have, for instance, the principles for review, or the principles of review in terms of not going to court directly, but having a period of assessing that the entire process was dealt with correctly in that regard. So these first 30 minutes I want to dedicate to that particular aspect, but obviously you can always go back to the previous session, because I know you always go back, as Sean said, to previous sessions with regards to the bid validity period. So Sean, perhaps I don't know if you want us to pause here for questions before we go into the meatier part, which is the due diligence.
I think it would be good to pause, Walter. Thank you.
Sure. Perfect.
Let's take a couple of questions. We'll just try to keep it to a minimum, or to 15 minutes at least, not a minimum. Yeah, are there any questions for Walter at this point? Because this was quite different to the Ekurhuleni
Yes.
Takabiza case, but I think it was primarily because of the wording that they included in their tender document.
Yes.
And if that wording was not there, then would we go back to the Takabiza case? Let's jump to Khao and ask Khao for some input, and then we'll go to Mike. Hello, Khao. Hang on a sec, Khao. I'm just going to, right, you can unmute, Khao. Go ahead.
Okay. Morning, Sean, and morning,
Good morning.
everybody. Thanks for the presentation. Just two quick issues. Does this case, the Aventino case, replace the Ekurhuleni case? Was it the Mambisa or something? Yeah, but they are similar case. Does it replace it? Seeing that both come from the SCA. That's one. The second issue talks to risks. And will it be wrong if the policy says, the SCM policy says, those that did not respond to the request for the extension will be presumed to have agreed? The risk here being, should only two or one respond, then the competitiveness pillar in section 217 may be compromised. Will there be anything wrong in doing that, to say failure to respond will be deemed as a response, and you continue with everybody else, including those that did not respond? Thank you, Chair. Thank you.
Great question. Thank you, Carl.
Let's
listen to Mike quickly. Hello, Mike.
Yes.
Yeah, I have two questions. A few years back, there was a court case where a tenderer was disqualified because out of a 200 or 300 page document, they omitted to sign a single page. And I think the judgment was that unless the missing information or the missing signature prevented the state from entering into a contract with that specific bidder, there was no ways that they could have been disqualified. But my question goes to the heart of procurement itself. Does the state actually appreciate how much money it costs the private sector to submit bids? And it's a common complaint, because sometimes you have large bids which require a very large amount of documentation. The actual bid specification itself, the technical part, is about 1 page long. And the rest is like hundreds of pages of documents that one has to read through, compile, most of which are actually unnecessary. And is there a way of actually making life a lot easier for both the evaluators and for the private sector? Because you can imagine a company that submits on average 20 to 30 bids a month, how much money it has to invest on a prospect of maybe doing business, maybe not doing business.
Yeah. Thanks, Mike.
Yeah.
Thank you. Good one. Let's jump to Angelo, and then we'll ask Walter to respond. Hi, Angelo.
Okay. Good morning, Walter. Good morning, all. Thanks, Sean.
Morning.
Look, I think mine is just a statement. I think, when we do the validity period extension, one must always keep in mind the financial implication that has on the bidders, because I mean, we're asking them to hold the prices for even a longer period than what's anticipated, and that depends on the pricing strategy as well. So I think we might just keep that in mind as well when we do ask for extensions, because we don't plan to delay anything, but things happen, but we should just consider that as well.
Good one. Thanks, Angelo. Good point.
Yeah.
Also, do you want to tackle them in any particular order?
No, I'm absolutely going to attack this. This is why I enjoy being here, because it speaks to the things that I'm always talking about. And I remember when I was at the AG, I was told that why do I think differently from how auditors think? But I'm like, I've been on the audit side, I've been in the procurement side, I understand challenges on both sides. So I'll start with that last comment, and because it links to the second question that was there with regards to the cost. Right. So I mean, think about 2025, that there have been VAT threats, there have been tariff threats, labor costs are going up, inflation, for instance, is an issue. And then now you turn it for something in 2024 when it was cheaper for you to supply this particular service, but now in 2025, it's a whole different ball game, and it speaks to that aspect of the competitiveness that was spoken about earlier on. So I'm going to start with the first one in that regard. So Takubiza, what happens to the Takubiza case? And I remember having a debate with someone on the day that this particular case came about, because obviously I had said, you know what, this particular case brings in a different nuance from Takubiza, and Takubiza still remains relevant. But when you think about it, at the end of the day, this particular case makes reference to Takubiza, makes reference to the REF case, makes reference to Telkom. So I would actually use this particular case as a catch-all case on the different scenarios that you will find yourself with regards to how you deal with validity period. So this case has got all the cases all wrapped in one, and I would seriously recommend that we use this particular Aventino case because of that reference. And with regards to one, what happens if you don't have the wording, and two, what happens if you do have the wording. In one instance, the validity period continues, in the other one, the validity period expires in that regard. So that's how I would answer that first one. And the second one, which I like, because you're thinking outside the box with regards to how do we deal with the wording, since we've discussed that wording becomes important. And I like the fact that you say that if you don't respond, we'll presume that you have accepted the extension of the validity period. And that's something that I used to have, for instance, as an example. So I'm going to give you something, that I used to do when I was in procurement. That's exactly how I did the wording, because I just wanted to make sure that we're still able to have, for instance, enough bids to consider, right? And what happens here is that obviously, if you continue to evaluate and that particular bidder then says, you know what, the price just doesn't make sense, we need to just go back and check, was there room for negotiation? Two, does the negotiation make it more expensive? Because remember, price still becomes a very important element. So in terms of mitigating your risk, it's either A, you say you don't need consensus, and then obviously you've got less bidders to evaluate, but it would affect your competitiveness depending on how many bidders are left. Or B, you can have this suggestion that you've had to say, we will assume that you've accepted, and then you continue to extend the validity period and then evaluate, and then you'll deal with whether or not that the winning bidder was one of those that had not accepted, but had been presumed to have accepted, and then see if they're still fine to give that particular price in that regard. And the third question here spoke about that case that talked about one page was not signed, right? And the court was very clear in that particular case to say, and in that case, they actually used the word constitutional. Is there a constitutional reason why having that one page not being signed arising this? And the court said this doesn't make sense, because you must always link that one page that's not signed to the ultimate goal on what you're trying to procure. If that one page has got no impact whatsoever on the sanctity of that particular document, then disqualifying them is not rational. And you're right. The cost of bids is something that must always be considered. So I've said on both sides. I've said on the side of being in procurement, but I've said on the side of preparing bids. So when I was in an attorney and there was work that was coming from a kind of state, we had to prepare large amounts of documents. So with regards to that, you're spending time, right? And remember, if you're in the professional services, time is money, and you're spending resources. So that those printing costs, for instance, if they want physical documents, that's money. So I think as procurement practitioners, we need to always consider that aspect to say, put yourself in the shoes of the bidder and how much time and resources that they spend with regards to submitting that bid. So at least when you're looking at this disqualification, you can build in those condonation powers if needs be, or C, just use logical sense to say, but having that one page not signed does not affect the particular aspect in that regard. So that's how I would answer those questions, and I think they're quite relevant and quite critical in that regard. So thanks for those there.
Well done, thank you. It's Tsepo has raised his hand. Let's give Tsepo a chance, and then we'll move on to the next part of your discussion. Go ahead, Tsepo. Good morning.
Thank you, Sean, and morning to all, and special and morning to Walter. Thanks for the presentation. I think it's a wonderful presentation. And one asked him or myself to think, especially when we just spoke about the signatures. I always think that signature is somehow an immaterial, but get to construction. We look at, signing the form of offer, which is the actual, commitment, and the impact is different. That's where you can be disqualified to say the form of offer in a construction perspective is different. And I've been observing over time, yes, you're right. There are some bid documents that you look at and you wonder, what happened here? Evaluation criteria that are very subjective, and an interpretation of subjective and objectivity being different. And also the foundation principles of public procurement itself versus, procurement in general, Some discussions are more key when we look at procurement as a general, a term. But when you look at a public procurement term, is different meaning, So I strongly believe that, at most times our foundations are different and how we deal with things are different. The validity extensions, for example, we know, sometimes it can be sketchy and things like that. Like Angela said, sometimes you are just forced about the situation. You only realize 30 days prior to, extension, to expiry, that you have to, extend, because, we work as a team. Someone, it overslept his mind or something, and now we have to extend validity, But when it gets to court, the rationale and irrationality that you referred to, it's about, is it a sufficient time for one to respond? At times you get away with it. You request an extension within 3 days, all of them, you push, you call, you do, they respond, and you are safe because there will be no litigation. But in actual fact, efficiency of time will be regarded as what time? 2 weeks, 1 week, and things like that. And this is an opportunity for us as we develop some regulations, but we also don't want to develop red tapes in our, operational areas. Yeah. So it's just a mix of, different situations, each one having its own merit depending on its challenges and things like that. Yeah. I just wanted to give that input, but yeah, thanks for that.
Good one. Thank you.
Awesome. Yeah. Thanks very much.
Good. Any comments, Tsepo, on Tsepo's comment, Walter?
Yeah, no. So I fully agree. I fully agree with Tsepo, and I like that part that we spoke about, not trying to complicate the process. Because, and you'll see later when I speak about challenges, for a procurement office, that there's so many moving targets, right? So you need to make sure that, for instance, that your SCM policy doesn't overcomplicate a lot of things and put unnecessary red tape, because I think red tape is something that affects everybody. There is certain red tape that you put in place because you're trying to make sure that you safeguard certain processes, but you need to think contextually to say, does this red tape push the needle? So I fully agree with Tsepo there.
Good one, thank you. And very interesting that 2 or 3 of the comments actually relate to disqualification criteria, which is probably going to be part of your next topic around due diligence. So why not get straight into it then? Well,